1014 is about transfer to and from family court and concurrent proceedings in the criminal court. So if there's something going on in family court with like neglect or abuse that's also going on in a criminal court, it may be solely retained in the family court, or if there appears to be no basis for the complaint, may be dismissed by the family court. If family court determines a petition should be filed, the proceedings under this act shall be commenced as soon as practicable. As soon as practicable. Nothing in this article shall be interpreted to preclude concurrent proceedings in family court and criminal court. In any hearing conducted by the family court under this section, the court may grant the respondent or potential respondent testimonial immunity in any subsequent criminal court proceeding. Another newish section in here is 1015-A. This is called court-ordered services. In any proceeding under Article 10, the court may order a social service official to provide or arrange for any provision of service or assistance to the child and his family to facilitate the protection of the child, the rehabilitation of the family, and the discharge, as appropriate, of the child from foster care. The social services official cannot be required to do any service that is not required or authorized to be made available pursuant to the Comprehensive Annual Services Program plan then in effect. In such order, the court may require the social services official to make periodic reports to the court. Nothing in such order shall preclude any party from exercising its rights to have the child removed or something, or return the child. Violation of such order shall be subject to punishment pursuant to Article 753 of the Judiciary Law. This is 1027-A. This is about siblings, placement, and contact with siblings for children who are removed and placed pursuant to Article 10. Generally, when a social services official removes a child pursuant to this article, he shall be placed with his siblings. However, if it's contrary to his best interests, different story. Placement with siblings or half-siblings shall be presumptively in the child's best interests. If such placement is not immediately available at the time the child is removed, such official shall provide or arrange for the provision of such placement within 30 days. If they can't place them, the social services official shall arrange for regular contact between the child and their siblings or half-siblings. Subparagraph C says that if a child is not placed with his siblings or afforded regular contact with his siblings, he may move through his attorney or through a parent for an order regarding placement or contact. The motion shall be served upon the following 6 people: the respondent, the social service official, the parent or persons having care, custody, and control of this child, having care, control of the sibling, the non-respondent parent, the sibling itself, if such sibling is 10 years of age or older. So that means 10 through 17 gets served, 0 through 9 does not get served. This is 1027-A. This is about siblings, placement, and contact with siblings for children who are removed and placed pursuant to Article 10. Generally, when a social services official removes a child pursuant to this article, he shall be placed with his siblings. However, if it's contrary to his best interests, different story. Placement with siblings or half-siblings shall be presumptively in the child's best interests. If such placement is not immediately available at the time the child is removed, such official shall provide or arrange for the provision of such placement within 30 days. If they can't place them, the social services official shall arrange for regular contact between the child and their siblings or half-siblings. I'm going to mention Article 1029 only because I just found a time rule in it. There's a 10-day rule in it. So it has to do with an order of... 1029 has to do with an order of protection under Article 10. And it says before or after the filing of petition, if there's, they can order, order protection. But if such order is granted before the filing of a petition, and a petition is not filed within 10 days from the granting of such order, the order shall be vacated. The order shall be vacated. So if the petition is not filed within 10 days, the order of protection shall be vacated. The temporary order of protection shall be vacated. The court may issue or extend a TOP ex parte or on notice simultaneously with the issuance of a warrant directing that the respondent be arrested and brought before the court. 1030 is about visitation by respondents. So this is when the kid gets removed and the respondent wants to visit with the kid. The respondent has the right to visitation, reasonable and regularly scheduled visitation of the child with a child in the temporary custody of a social service official, which I am now going to abbreviate as SSO. A respondent who has not been afforded such visitation shall apply to the court for an order requiring the SSO having temporary custody of the child to permit the respondent to visit. A respondent shall be granted the visitation unless court finds child's life or health would be endangered thereby, but court may order supervised visitation. An order made under this section may be modified for good cause shown upon application by any party or child's attorney, and upon notice to. So this motion that the respondent makes has to be served on the child's attorney and the SSO, period. That's it. That's the only people that they have to serve. So an order made under this section, upon the entry of an order of disposition, it terminates. So let me repeat that. An order of visitation by the respondent shall terminate upon the entry of an order of disposition pursuant to Part 5 of Article 10.
From the beginning?
No.